Good morning, everyone.
Good morning.
For the record, my name is Warren Limmer. I'm the chairman of the Judiciary and Public Safety Committee in the Minnesota Senate. Today in the Minnesota Judiciary Committee, we will be reviewing and voting on Senate File 2672. It's a bill addressing the confirmation of Minnesota Sentencing Guidelines Commission members. And I'm bringing this forward foremost because of the issue of separation of powers. We have a commission with members who are moving towards acting very much like a de facto legislature. The vast majority of those who serve on the commission are unelected individuals, and most are appointed by Governor Walz, or any governor for that matter. They have no true accountability directly to the people of Minnesota, which is different than those that are elected by the people of Minnesota. And if you do a poor job, the public will hold you accountable in that following election. Quite often in the past, we have had in Minnesota a number of boards and commissions. And the legislature has seen fit to require some type of vetting by the legislature. We call that confirmation of members of those boards and commissions. I'm simply extending that very same concept to the Minnesota Sentencing Guidelines Commission. As a background, 3 members who serve on the commission are appointed by the judiciary or by the Supreme Court. And the remaining 8 members are appointed by the governor to a 4-year term that runs and coincides with his term of office. My concern is that the Minnesota Sentencing Guidelines Commission has increasingly become more interested in writing policy, mainly modifying and reducing criminal sentences, or more recent, in the past, in 2019, they adopted a policy to change all probation laws, the extending or the term of probation to a 5-year cap for most crimes. Quite honestly, I think this is alarming. When an organization appointed by just the executive branch, without the legislative branch that represents the public, is making serious changes to criminal sentences. They were given that opportunity back in 1980, but I don't think, even I was not in office in 1980. However, I don't think the legislature, in discussing with those previous legislators that were responsible for that decision, they never had the concept in mind that there would be wholesale changes to criminal sentences by an unelected body. It was more intended to tweak individual items, not wholesale changes. And so as the commission becomes a little bit more policy focused and are making changes, serious changes to sentences and probation terms, I think it's reasonable to have the legislature confirm the candidates that are appointed by the governor. We're not doing anything regarding the judges that are appointed by the Supreme Court, but just in the executive branch. And I've long stated that broad changes and sweeping reforms must be analyzed by those accountable to the public. And in this particular case, the Sentencing Guidelines Commission members that are appointed and not elected need to be vetted and confirmed by the Minnesota Senate. And that's basically the bulk of the bill that we're going to be hearing today, and I'll stand for any questions.
Could you remind, you just passed laws to change the policies that they make that you don't like? I mean, if they put in a new type of sentencing or something that you're not in favor of, couldn't they be accountable just by that way, elected officials?
Yeah, that's a good question. The legislature can and has the authority to alter or reverse the decision by the Sentence Guidelines Commission. However, in the state of split government, I would think that's unlikely. And quite honestly, that means that if it can't be changed by the legislature, that means that the Sentencing Guidelines Commission has the trump hand. And they can make other changes as well. There's really no restriction on what they can do. And quite honestly, I find that troubling.
Senator, can you expand more on this idea that they're more interested in writing policy? Because inherently, isn't their purpose to make suggestions on sentences, which would seem to be that that's the whole purpose of what they're doing is policy regarding sentencing. Mm-hmm. And also, too, as I understand it, that it's not a set in stone, that there's still discretion on part of the judges related to this. Is that correct? So with those two things in mind, why is this necessary?
I don't understand the discretion on the part of judges. Oh, in the event that judges in a criminal case.
Misunderstanding, but I
Right.
thought it was that the Guidelines Commission says X on a certain sentence, but the judge has ultimate discretion on should they have a higher penalty. So with that in mind, plus what the statute says about their role, I want you to expand more on the idea that they're venturing into policy.
I understand your question now. In the event that a governor or a judge wishes to extend a different sentence, they always have that discretion. However, when we make sentencing recommendations, minimum to maximum ranges, we give that judge a range in which to work. They're changing the range, and it changes the whole dynamic. And quite honestly, I've got to repeat, this is more of a separation of powers issue than anything else. Giving the executive branch, through appointment of a vast majority on a commission, the authority to change statute that's already in law is contrary to a democratic process. We make law from representatives of the public in the legislature. And when those provisions are acceptable to a governor, that governor signs it into law and is embedded in our statute books. This changes the whole thing. It's a complete dynamic shift. And quite honestly, the power belongs to the people. It's through the legislature. And we're just trying to get our hands on it and give a little more direction. We're not making a proposal to appoint directly from the legislature. We just want a process to see who's getting in there, what's their philosophical viewpoints. Is it reflective of perhaps the people back home, the voters? Those are the important concepts.
Can you talk at all about how the, I guess, recent controversy with the commission regarding the proposal to eliminate enhanced penalties for people who reoffend while on probation and parole? It sparked a lot of public outcry. Republicans were sharply critical of it, but ultimately that was tabled, with no set date in mind for when they'll bring that back up. How much did that example weigh on the decision to bring this bill forward?
Well, when the first major step to revise statute in the form of a probation cap occurred, it did trigger an alarm. But the legislature did not react immediately. I think that was good on their part to see where it was going. There is concern, though, I must underline, there is concern treating almost every single crime identical in a criminal sanction. And keep in mind, Minnesota is close to second or maybe the first lowest incarceration state in the country. We rely on probation to be that counterbalance. And it's cheaper to have someone on probation. And that's why Minnesota is a little bit of an outlier when it comes to comparing it with the other states. we rely on probation a little longer in term. Sentencing Guidelines Commission apparently doesn't recognize that, and they want to shrink that term of probation to a 5-year limit. There's no question that they are ignoring the concept of proportionality, making the penalty fit the seriousness of the crime, which is also contrary to the whole concept of a sentencing guidelines grid, where we recognize not only the severity, but the history of that particular criminal. And proportionality is a mainstay to previously written statute. So when the next concept started coming forward, we did become alarmed. There seems to be a pattern now that's emerging. And it's simply the question is it the intention of the executive branch to sidestep the legislature and modify and make their own law through the Sentencing Guidelines Commission candidates that are appointed by that executive branch?
If this were to become law, what kinds of attributes would you be looking for as chair of the judiciary for future appointees to this commission?
I don't think they would be far different than what they are now in consideration. There's so many people that are representative of law enforcement. So many are representative of corrections field. We have the Department of Corrections Commissioner, Paul Schnell, on it as a written requirement that he or a designee is on that committee. We have representatives in the victim classification, victim of crime. I believe we have someone who was a former felon and was imprisoned, is now out, and they also are. I think it's more of a, not so much a checkoff of what your background is, but what is your philosophical view towards sentencing? And I think, quite honestly, that's a good thing. And a wide spectrum should be included. I just think the legislature needs to have a hand in vetting, and they need a hand in confirming, just like we do in a number of other boards and commissions.
There is at least one member, right, who is subject to Senate confirmation, the Commissioner Schnell. Do you expect to look at his confirmation this year, or consider rejecting him?
Confirmation of any commissioner is the responsibility of the Senate. It's their option to consider. That really shouldn't be a mark for or against him being a member of a Sentencing Guidelines Commission. It would be more broader than that. And I don't have an answer for you right now regarding the future of Commissioner Schnell.
But you don't think his role in that commission has, you haven't looked negatively upon that or anything that might influence your opinion or your action on confirmation?
I think the role that Commissioner Schnell had in the Sentencing Guidelines Commission in recommending a 5-year probation cap is concerning.
Just to clarify then, so your bill, would it require Senate confirmation, or would it be like commissioners where they are appointed, but you would have the power not to confirm?
It would require.
Okay.
Anything else?
I've got just a little separate. It's on the same public safety topic. The governor.
By the way, how's your dad doing?
He's doing well, thank you.
Good.
Retired and happy. The governor and the House have made part of their public safety platforms a lot of money for community groups, like intervention groups, violence interrupter type style, job training, that that sort of bucket of nonprofits. That's been a large plank of their public safety platform. Just give me your sort of thoughts on that, your response to that. Is the Senate interested in all in funding these types of programs? Do they see it as worthwhile or helpful?
Yeah, Mr. Ornstein, I have not looked at their bill. It's the second day of the legislative process. Interesting concept. The concern I have is that the whole concept of community policing is supposed to build a more warmer relationship between law enforcement and a community. By putting third parties into that mix, you don't build that relationship with a police officer to their community. So but you certainly do build up a budget that's dedicated to nonprofit organizations. And quite honestly, I don't know if they're missing the mark or not once I read the bill and understand it, but that's my gut feel. I think we need to have a tighter relationship in community policing directly from law enforcement personnel with a community. That's it.
All right.
Thank you.